This has been a day off in the trial of former New York State Assembly Speaker Sheldon Silver in his federal corruption probe. Now, the courthouse, it closed today for Veterans Day, but so far, prosecutors have carefully established the money trail that they say shows Silver's guilt, that he got close to $4 million in referrals on asbestos cases and cashed in other cases for relatively little, if any, work. They've also established that Silver essentially by himself controlled who got billions of dollars in state health department grants, or at least millions. But prosecutors, they have yet to establish what is known as the quid pro quo behind Silver's actions, that he gave out money in exchange for something, or that people acted for Silver's benefit because of his political power. Now, emails that came from physician Robert Taub, he a prosecution witness who got immunity in the deal here, but was basically one of the key players in this. Well, these emails are very interesting, and I'll read you a couple of them. One of them says, this again was from Dr. Taub to a colleague of his saying, as the Bible says, we need to get past the time when each man does as is righteous in his own eyes. Usually success is propelled by greed, envy, or both. I thought you knew that. And on that point, he was referring to contributions from the law firm of Silver that had stopped. And then people question, why are we still, or the implication, still sending cases or referrals to him when he's not contributing to basically the service. This next email says about his relationship with the speaker, Dr. Taub says, I will keep giving cases to Shelley because I may need him in the future. He is the most powerful man in New York State. Okay. Now, on the front, that may look bad, okay? But whether or not that proves, as we say, a quid pro quo is something different. I'll get to what might be in the jury mind a little bit later on in this conversation, but explain for me the difference in the legal profession between a kickback and a referral. Is it important, if at all, that the attorney does any work on the case, or is being a rainmaker completely legal?
Well, you can be a rainmaker if you're part of that law firm. If you're a member of the law firm, there's nothing wrong with you being involved in getting a percentage of whatever the firm generates. If you're outside of that law firm, then technically you're supposed to do some work on that case. Now, it's not quantified how much work it has to be. It may be a client conference, it may be you're doing depositions, it may be you're drafting memoranda, or it can be something even simpler than that. The thing that's interesting is when you look at what the doctor said. The doctor says, more or less, I'm going to keep sending this business his way because he's the most powerful person. So he's saying that if you're the most powerful person, I'll do whatever it takes to be in good graces with you. Well, the person that's more powerful than Sheldon Silver is the United States government. And right now, they want him to do something different, something against Mr. Silver. So if I'm defending Mr. Silver, I'm going to say, well, you heard him say it. You know, whoever's the most powerful, that's who he's going to go with. Right now, he's going with the government against little me.
Now, in fact, when pressed on this from the defense attorney, he said, was there a quid pro quo? Was it established that you had to send him these referrals here, or else, in effect, the spigot would dry off? The $500 grand, in effect, that of state dollars was given from Shelley Silver with zero oversight, it turns out, that was testified also by members of the budget officials, et cetera, out of Albany. They appropriated monies that he would give, but he could give it in any different amount of tranches over whatever time period that he and he alone decided. But that was legal, whether it's disgusting or not. That was legal. He decided to give the monies, and it seems, at least implicit by the emails, there was, if not a stated condition, that, hey, you know what, these cases better come over to my firm. Is that enough, Brad?
Look, there's that, the feds are making out the case that clearly, if Shelley Silver is giving $500,000 to the doctor with the expectation that there will be cases referred back to him, then that would be the quid pro quo that we're speaking of. Okay, how tight that is, because when the doctor was asked, you know, did you guys agree on this? Is this something that Mr. Silver said to you? Okay, the answer was no, not in so many words. However, you know, the behavior and conduct is what the feds are relying on to make this quid pro quo case.
Okay, Jimmy, help me out. You got 12 people in a box, okay? And they're going into the box, no matter what they say when you're doing jury selection, they don't like Albany, okay? Right. Every single poll that I talk about every single night says they think they're all crooks. Unfair as it may be, the impression of the public is they've had it up to here.
Right.
Cases like this don't help. So they're going in there and they're hearing, wait a minute, the guy's got 500 grand of my money, well, taxpayer money, and he gives it to basically this clinic here for them to do valuable work here to help out people with terrible afflictions as it relates to mesothelioma. And he got $4 million, and he didn't so much as write a brief. So does it matter that they can't make a direct connection where there's a paper trail that says you do this for me or I'm turning off your water? Or do juries say, my BS detectives just beeping way too much on this, that's enough for me?
If you had a paper trail that says you do this for me and I'll do this for you, then it's a 4-minute acquittal. A 4-minute conviction. There's nothing
But
to
that
think about.
probably doesn't exist.
The right defense attorney addresses that. When there's an elephant in the room, introduce it. You look at the jury and say, ladies and gentlemen, unseemly? Absolutely. Does it disgust you? Absolutely. It doesn't mean it's a violation of the law. Look, when a major contributor to a campaign writes the check, is he not expecting access to that person? And is he not going to email his friend and say, I am going to keep contributing a lot of money because he's the most powerful person in the world and I want to keep in contact
But
with
that's
him?
different. You're talking about access. This has to do with enrichment.
Access can lead to enrichment.
Okay. No,
Why do I
access
want
might
access
be,
to you to go to lunch?
Access might be that, hey, I might have some pending legislation that I'd love to have an advocate in Congress to speak on the behalf of my position on this particular issue.
Yeah, but that
This is
email-
something more direct.
That email, though, was small in terms of the evidence that's been
Right.
presented.
Right. I'm
That
just
email
saying that-
just says that, hey, he's important, I want to keep a relationship.
Take the
I
email
get
out of
that
the way,
part.
Brad. At the end of the
It's
day,
the behavior.
time out.
It's behavior.
Right. It's not like he wrote the check or the firm wrote the check for 500 grand. My point is, this gets complicated, as you know, because you're up in Albany all the
The
time. You're a
question
lobbyist.
becomes did Shelley give that $500,000 to the doctor's organization, understanding that he was going to receive cases back, and did that doctor know that that money was for that? As long as that behavior, whatever the conduct, the discussions surrounding it, all the evidence that you're starting to hear, so long as that comes together and shows that there was an agreement, enough of an agreement, that the jury would be satisfied that there's a quid pro quo.
You could apply those principles to virtually every government in New York State. You're going to find that if someone's a town supervisor, somebody loosely connected to them or maybe not so loosely connected gets the contract to
because
do
they're allowed to have a
sanitation.
second job. Because here's where I get to, Mayo, and I know we're time, but it seems that the argument that he and his defense are making could actually be used to hang him, which is the following. Hey, listen, I'm a part-time legislator. I'm also a part-time attorney. That's the way that we set up the state legislature. For people who don't know, when it was originally designed, it was supposed to be a one-day-a-week job. Right now, and Brad will tell you, they're up there 3, sometimes 4 days a week, and the other days are really fundraising. So what are you getting really out of an attorney who is really a legislator who moonlights as an attorney? They're not handling your cases. You're basically retaining them for access and for influence. That's the way it works. So come back to the question, which
But
is...
he's not on trial for that.
Okay, but here's the point, Brad. He's saying, hey, I'm counsel. I did all this work as an attorney. I'm not a legislator. But then he's going to want to turn around to say, wait a minute, I'm a legislator. I get to use my access to get 500 grand here
Well,
of taxpayer money to basically
You
create
can't
this
know it.
relationship.
And what Preet
He
Bharara
wants
said
it both
specifically
ways.
is this, and I get what you're saying. What Preet Bharara said specifically is you cannot monetize your position as a legislator or any elected position. Okay, and that's
How the heck
the
isn't
argument that right. And look, the question becomes: is Preet Bharara can say it? The question is, what's the law?
Okay, and here's
that's
my
where we
final
are.
question, though, Mayo. You've looked into juries when you've laid out cases, and sometimes the prosecution may have a hard case, but they feel sympathetic to your client, or vice versa. You know, they have flimsy evidence on it, but he's such an unlikable character, they're looking for a reason to convict him. In this particular case, how important is the charging of the jury by the judge and the instructions? And secondly, is he already, Silver that is, going into this, where he's almost got to prove he's innocent rather than the other way around?
Well, I tend to think that anytime you're a criminal defendant, you have to prove you're innocent to begin with. It's nice we have this law that says you're innocent until proven guilty. The reality is that whenever you ask any juror, do you think that the person must have done something wrong because they're sitting next to the defense attorney, the honest hands go up, and you'll be amazed at how many hands go up. And they'll say, well, I believe he's innocent until proven guilty, but he must have done something. And those are honest people. So that's just the reality of it.
All right. Now, on the other side of the break, and again, we'll have live reporting from Lower Manhattan tomorrow as the trial resumes. Dominic will be down there. But when we come back, the Robert Durst murder case, it still has tons of loose ends and so much on the American psyche that they're fascinated by this case, and for understandable reasons. Did the real estate millionaire kill his wife, who disappeared from the Westchester home decades ago? Well, his friend in California was murdered, but did he do it? Former Westchester DA Janine Pirro, she's trying to get to the bottom of it all, and she's got a new book that's out. I'll be talking to her tomorrow, but what I want to ask the table around here is this book going to actually complicate the case? We'll be right back.